Supplementary 1. Pronouncement of judgment.
Just operative part, I will read out. My lord. Viewed from above, the impugned judgment in order of conviction passed by the Special Judge POXO in POXO case number 8 of 2022 cannot stand scrutiny of law and is hereby set aside and quashed. Consequently, the order of sentence.
Any mention? Lordship, I beg to mention item 6 of the hearing list.
Advertisement.
Yes.
No objection, my lord.
Yes.
Your Lordship, I'm praying for 2 weeks' time, Your Lordship.
It's almost infractious matters. Why you?
Last occasion also, your lordship. Same thing was expressed by this
Remains.
court.
What is the use of dragging this kind of matters? Just tell us.
Your Lordship, we need to take instructions from the
That is
petitioners
pending
here.
for instruction for maybe for more than 2 months.
Your Lordship, they consist of 11 members of the association. So,
But then you should take instruction. That cannot be ground for this thing.
Your Lordship.
Let's say on the request of the petitioner should be stuck for 2 weeks. Please make sure you should not come and ask for time for this kind of.
Lordship.
Finish it.
Highly obliged.
My pleasure,
Yes.
Lordship. I beg to mention item number 10. I pray for 2 weeks' time, Your Lordship, because our copy got burned in the.
Yes, sir. 2 weeks on the request of the petitioner. You can reconstruct the file within 2 weeks. Okay, 2 weeks.
We'll get the copies from them.
2 weeks on the right. The right
Obliged.
property.
Lordship, I beg to mention item number 9.
Item number
9.
9. Say loudly. I heard this.
I'm praying for 3 week time.
You were for
Week for hearing.
Therefore, the petitioner, Lordship.
what is the matter about?
Lordship, this is a matter for discharge, my lord.
When do you want it? Do you have any objection, madam?
No, Lordship, because Mr. Bora has already stated yesterday that he would be taking adjournment.
This also make it 2 weeks after on the request of the petitioner. Yes.
Much obliged, Lordship.
Lordship, similarly, item number 2.
Item number 2.
Yes, Judge.
Item number 2. That is order matter. Let it come up. Just wait. Somebody said something.
Lordship, Suparna Shyam, advocate, appearing online, my lord.
Well, I cannot see you. You are not visible.
Lordship, I don't know, my
Anyway,
camera
anyways.
is on, but I'm.
It's okay. Call the matter.
Supplementary cause list. Item number 1.
My lord, I humbly pray that the matter be passed over to the end of the board. My senior is going to argue the matter. My lord.
What is the matter about?
It's relating to the check bounce, my lord. Check bounce case, my lord.
You are seeking Quashing of the proceeding.
Yes, my lord.
Who is the other side? Oh, State Bank of India. You have not supplied any advance copy?
Not yet, my lord.
There is no standing counsel for State Bank of India?
My lord, we have
With the
not
rural bank also.
received any instruction of the same. Kindly have it after, pass over to the end of the board, madam. The senior will be there.
Call it at the end of the board. End of the board.
End of the board, madam. Highly obliged.
Oh yes, yes, yeah, Mr. Nagar. Come.
We will have it end of the board.
Why? Once you are here. Okay, okay, end of the board. Yes.
Main list, item number 1.
Maybe please your lordship, the state has given their response. I have a copy, so I felt that your lordship, this can be disposed of because we are making a very small prayer for allowing us to get the unrelated document which were seized by the IO.
State has signed an affidavit.
They have
Your
filed.
lordship, you have filed. Yesterday only.
And to that effect, in fact, we want to.
What is the petition about, Mr. Mahanto?
The petition is, if your lordship please to, in fact, I want to give this citation. I have given a copy to the other side also.
The matter will be, this will need a lengthy hearing.
Not exactly that, because earlier there was a judgment from this
It should
honorable
not require
court
lot hearing.
given by Honorable Justice
No,
Dinglo.
then we'll take it up for hearing next week.
Oh, next week on 15th.
15th is over.
15, if no inconvenience, also Friday.
This side is not.
No, that is April. Decide March.
Then there will be some division bench, probably some division bench matters fixed next week. That is sort of problem is.
Let it be
You can
on
have it
15th,
after 2 weeks.
after 2 weeks.
If it is not inconvenient.
No, it's
Well, otherwise, if you want it today, then we can wait and we can take it up at the end of the.
or
15 possible. I think
There's no stay. That's why we are saying next week.
next week, okay. Lordship, any day next week, 13, 14, 15, any day.
it can be on 13
This
also.
next week may be difficult for this court. There are some fixed matters. There may be some matters, DB
As you-
matters
as you-
also. fixed.
Okay.
Let the trial be stayed then.
Now, you may conduct the hearing. If order cannot be delivered, then that will not serve your purpose. What is the issue? What is the
Issue means your lordship, as per the earlier order,
yes?
if your lordship please to turn to page 335. The order dated 10/8/2022.
1 minute, just.
Page 335, your lordship.
335 it is.
In WPC Criminal 2 of 2021, your lordship.
335.
335, your lordship.
Yes.
So this was given by Honorable Justice W. Dingto, your lordship. The paragraph 2.
Yes.
The learned counsel for petitioner has submitted that pursuant to the relevant order passed by this court, the investigator has allowed the petitioner to peruse the voluminous documents and to sort out the relevant documents for which copies of the same be given to the petitioner. In this regard, the petitioner has submitted that the IO had a meeting with them and some relevant documents have been identified. However, to complete the process, it takes some time. This being the preliminary prayer of the petitioner, the learned counsel has submitted that the other prayers would not be praised. If this could direct the concerned IO to cooperate with the petitioner and to supply the relevant documents and papers entitled by them, in the meantime, until the said process is completed, the proceeding before the trial court be kept in abeyance as was done so by the interim order of this court. So, Mr. Khan, then lastly, paragraph 5, it comes here. The consideration of submission made without going into the merit of the petition, this court is convinced that this petition may be disposed of on the limited prayer made. According to the ongoing process of identification of the relevant documents and papers entitled by the petitioner, for which IO is directed to sort out and hand over copies of the same to the petitioner, and on completion of the process be continued, with a report to be filed before the trial court for continuation of the proceeding after the same is completed. However, I is directed to complete the process preferably within a period of 3 months. So, in compliance with this order, we have checked some documents. Few documents were given, but most of the documents were not given. Then
Which you are given and which you are not given. And
that's
where
why we wanted a prayer in our prayer portion. If your lordship is pleased to
you want to say that this order has not been complied with.
not completely complied with.
Then whether is there
And
any
the
necessity
report
of
also has
passing
not
the
been
same order
submitted.
again?
As per this order, are you supposed to submit a report to the concerned
That
court?
is okay. That is okay. If it is not done, let
Not
us take your submission as correct.
So
Now,
now what happened?
is there any
Therefore-
requirement of again passing same order?
Yes, no.
Or
Some documents were given, but some were not given. Those which were not given, therefore we made a prayer, your lordship, at page 32 of the petition, your lordship will see.
page 32 of the petition.
Of my petition. Lordship has got that. Permit the petitioner to produce a list of documents as per the annexure P11, which has been withheld by the investigating officer prosecution at the time of filing of the final report dated.
But then what it has to permit? Here you are to permit the petitioner to produce the list.
The document.
List of document as per so and so.
Then thereafter it comes your.
No, that is, but then the earlier thing you said some of documents have been identified, isn't it? The
Yes.
order which you have referred to. Then
Next prayer, your lordship.
that liberty is there already there.
Yes. The next prayer, as per the order dated 10/8/82 or 22, your lordship, to file the report before the trial court in terms of the order dated so and so. Then next prayer, direct investigating officer to prepare two separate index of realized and unrealized documents which were allegedly seized in so and so case, and hand over the copies of unrealized documents to the petitioner for the purpose of commencing a fair trial. So for that we have moved before the trial court also. Then trial court give the order on 26/6/2023.
Yes.
That order is against that we have come, your lordship.
No, what the trial court?
Trial court didn't allow us to give that document. Your lordship.
See, the court has not got exactly what you want, what relief you want here in this case. You see, to direct the investigating officer to prepare two separate index. Now,
Yes.
is it the duty of the court to do that? Why?
No.
What is it not that the law prescribes of what should be done in submission of document or not? Is it not that it is contained in CRPC or not?
No, CRPC
Manner and mode
it
which
is
is
there.
to be done,
It is
how the
there.
documents to be submitted.
Your lordship was when the unrealized documents for the benefit of the fair trial after Susikala's case and the Mono's case, your lordship. Therefore, we have given the suggestion, your lordship. So we are entitled. For that, we have approached this court again.
What is the stage of the proceedings now?
State,
We'll be
it
leading a detailed hearing.
is for hearing out
We'll
for
let
the
it come up for
charges.
hearing. We'll just hear this matter.
Yes.
We'll have it after 2 weeks. You have filed affidavit.
Yesterday.
Earlier, Mr. S.K. Hassan said that he was specifically, Mr. S.K. Hassan appeared in this matter as a special counsel.
Lordship.
Mr. S.K. Hassan,
Yes.
he's no more special counsel here in this case.
No, Lordship, I am a special counsel. I am entitled to 2 junior counsels.
So he said and he appeared that he is engaged as a special counsel.
No, Lordship. Assisting counsel.
He did not say that. Anyway. But then you are already there as a PP.
No, this is a case where I'm specifically appointed as special counsel, SPP,
Anyway.
with 2 assisting counsel, not
Your affidavit is on record.
serious. If
You are opposing the or you are what stand you have taken?
Lordship, our stand is this: the documents were given.
So no fresh order is called for.
No fresh order is called for. Their case is there's some additional documents they ought to have been given, and they're relying on Supreme Court judgment.
Those documents are identifiable. Which has been given and which are not
That is
given.
why hearing is required for that. If it is identifiable, then whether they are entitled to.
This court will not take up the task of identifying documents.
Absolutely.
No,
correct.
obviously.
You are absolutely correct.
Okay.
May I submit, I am for one of the petitioner, but the law now envisages that it is the bounden duty of the prosecution. The Supreme Court has now, the Constitution bench has upheld that it is a bounden duty of the prosecution to supply us the copy of the underlying documents also. and that's precisely our whole grouse is.
That's
That
what-
they are not doing it. What has happened, my lords, on the first occasion asked us whether we know whether what documents have been seized.
What are the unrelated documents?
Man, the unrelied document, man, what they did was they seized the entire campus of the university. They took away everything in a truck. They did not, all those seized documents don't even have my signatures.
What are those all documents and all those?
Man, all documents.
Can you
I have
identify?
got some documents, my lord, under the last order passed by Justice Dingdo. Some relevant documents were given to us, but for others, what was told is there is another malkhana which is in the exclusive domain of the investigating officer.
Now, what basing you are saying?
So, my lord, there are a lot of documents. There are two malkhana, entire rooms are filled.
That is the factual aspect. How this court knows it? It is your submission.
It is my submission, and it is
Yes.
not denied by the other side. Kindly have their
No, if you see, it is onus is only. It is burden is only. If you say the sum of the documents, you are entitled. You are entitled to. In such a case, it is duty to identify those items.
I don't need to. Kindly have the judgments of the Supreme Court.
Then what documents? What is
The
related
documents
and
which have
unrelated?
been seized and they are lying in the malkhana. The duty is to give the
You want
unrelied.
this court to pass a blanket order to give you all those unrelated documents.
Not unrelied. They
And
have to
then
give the
you will
index.
say that no unrelated document was.
That's my whole grouse. Kindly have para 8. Para 8 has not even been specifically denied by the other side. They say
Okay, anyway, we will have it for hearing.
very well.
Hard so and so. An affidavit in opposition on behalf of the state respondents. There is no other private respondent
No.
has been filed. Parties submit that matter is ready for hearing. Listed for hearing after 2 weeks.
Keep
You take back this. Take back this.
Yes.
Take.
Item number 2.
Much.
We'll go now. Take this.
This one. Yes.
Lordship, in this matter, I am entering appearance on behalf of respondent number 4, Lordship.
What is this matter about, Mr. Pandey?
Lordship, this is online fraud, Lordship. The petitioner had
Criminal litigation.
sought to buy one Bolero vehicle from an online platform, Lordship. He was the vehicle. He did not get the vehicle,
You are
Lordship.
appearing for respond number
4, Lordship.
And what about 5, 6, 7, 8?
Lordship, I'm for the state.
You are not visible, madam. Where are you? I can hear you, but then I cannot see you.
Lordship, I have switched my camera on, but I'm not visible, Lordship. I don't know what has gone wrong. My camera is switched on from my end.
Okay, you are appearing for respond number 1.
Yes, my lord.
Then 2, 3, 5, 6, 7, 8. Who are there? 2, 3, 5, 6, 7, 8.
We already take step, Lordship.
Have you taken steps?
Yes, Lordship.
Have you taken steps?
Yes, Your Lordship.
Respondent number 3 has not been received. What about the other respondents? What you will do? There is no service report.
We will file the service.
Yes.
We will file the service report within 2 weeks.
Then when did you take steps?
To February.
Yes, 5-2. Have you checked the office note? See, your notice on respondent number 2567 and 8 has returned unserved. 3 service report has not come, the 4 has appeared. So what you will do in respect of those 2567 and 8?
We'll take step again.
Will take fresh steps.
Yes.
Let them take fresh steps. And whatever respondent number 3? Okay, Mr. Pandey. Mr. What Pandey? I just.
Yes, Pandey, Lordship.
Yes, Pandey. I said, yes, Pandey. Learned Counsel enters appearance on behalf of respondent number 4. The notice issued to respondent number 2567 and 8 has returned unserved. The service report of notice upon respondent number 3 has not yet been received. Just record her name, Miss So and so, learned counsel for the petitioner. Submit that she may be permitted to take fresh steps for issue of notice upon respondent number 2567 and 8. Comma. Prayer allowed. Steps in this respect shall be taken within 2 days. Okay. Then full stop. Await service report. Respondent 3. This is matter after 2 weeks.
Deeply obliged.
Obliged, my lord.
Item number 3. Item number 4.
Lordship, in this matter, we have already taken step, Lordship, but however, it was undelivered. I pray that we may be allowed to take a fresh step, Your Lordship, through dusty service.
You have seen that, check the thing, of not this has been returned.
Yes, Lordship.
Because perhaps because of the wrong address, it says NLF not, the note is not.
Lordship, in this matter, I'm praying for 2 weeks' time, Lordship. Because my senior
Why
is on
nobody?
leave,
Oh,
Lordship.
achha, you were there. I thought it's coming from their side. You're praying for?
2 weeks' time, Lordship.
Why?
Because my senior is on leave, Lordship.
Lordship, I'm praying on behalf of respondent number 1.
You have
I
objection?
No objection. I have no objection.
No objection. Okay. Just after 2 weeks, as per for by the Learned Council. Or Learned Council of the petition.
Obliged, Lordship.
Thank you, Raj.
Hearing item number 7.
Yes.
Well, look, this is a criminal writ petition against the finding of the BSF court. Well, here what has happened, after being tried of an offence by the General Border Security Force Court, I was found guilty and convicted for an offence under 376 IPC. I was terminated from service and I was awarded a 376 7 years imprisonment. My lord, this matter, my lord, actually will take at least the entire day because my lord, the paperwork is here. A lot of things have to be read out. Is he available?
If it is not possible today, then it will go after 2 weeks.
My lord, not a problem after 2 weeks, but my lord, on such a day where my lord, at least this matter can be heard, it will go on for at least 3 hours.
See,
minimum.
normally it's okay. If required, we will continue for 2 days. There is no problem.
My lord, that is that we can do.
The only thing is that there
Because,
should
my lord,
not be much gap. You see, like then what happens? Everything goes
yes.
away from.
But what has happened here is, my lord, of course, my lord, when it comes to matters like this, my lord, when the finding of a court martial or BSF court is challenged, the scope of judicial review is very, very limited.
Not like appellate court.
Not like in appellate court, my lord, but there is no hard and fast rule, my lord. There are certain judgments of the Supreme Court where, my lord, the leverage has been given to the High Court if on a case-to-case basis, my lord, if it is pointed out, if it is made clear that, my lord, evidence has to be looked into, then the court can look into evidence. Now, this is such a case, my lord, where there is no evidence at all. There is no evidence of 376, my lord. I don't know on what basis they have come to a finding that this person is accused of an offence under 376.
If it is says the finding is absolutely perverse,
My lord.
then definitely we can interfere.
Well, that is what is my case is all about, my lord. Otherwise, generally, my lord, what happens, you can only look into the technicalities, whether the entire procedure was followed to the T or not. If not, then the court can interfere.
Perversity also says, supposing there are 2 plus 2 is 4. Now
My
you
lord.
say it is 5. Definitely we will.
Absolutely, my lord. This is a case where they are saying 2 plus 2 is 5. So, my lord, we can have it after 2 weeks, and my lord, of course, this man has been inside for quite some time. On the next date, we can finally argue this matter.
You is all right. There's no problem. We'll have it.
Obliged.
On the request of the petitioner, list after 2 weeks.
Item
Bring
number
some
8.
law with the previous one.
But sorry, my lord.
The one which we have adjourned just now.
My lord.
On the day of hearing, just bring some law to
I will,
assist
my
the court
lord.
about that thing.
I will, my lord.
To what extent we can go?
Yes, my lord. There is a very
That will
recent
be the
judgment of the
vital-
Supreme Court, my lord.
Yes.
I do.
What is this?
This is a petition under 482, my lord. My lord, actually, this case basically, well, at the beginning of this case is a marriage between the party number 1 over here and the respondent, my lord. Here, what has happened, my lord, the marriage did not work out and a divorce was filed. My learned friend's client is filed for a divorce. And, my lord,
Your wife.
I'm the husband, my lord, unfortunately, the husband. Then, my lord, what has happened, my lord, during the pendency of the divorce, my lord, there were some talks of settlement. My lord, we were okay with settlement. However, my lord, the demand was such that, my lord, we could not agree to the demand. We quoted a certain amount of money. They
I've
quoted
seen
a
in
very,
Mr.
very
Shan's
huge.
case, most of the case, there are other matters.
Absolutely. So, my lord,
because of that thing.
well, we are still agreeable. Well,
With the
we are
problem with the
till-
party or with the. We do not know.
I don't know. Well, I made it very, very clear. Well, this is the only thing. But this boy is absolutely bankrupt. This is his family which is at least trying to help him. But my lord, nonetheless, my lord, then thereafter what has happened, my learned friend has filed 2 petitions. First of all, he filed a petition under the Domestic Violence Act. There I was arraigned as an accused. There also I was summoned. Bailable warrant was issued against me. My lord, then my lord, immediately I came before this Honorable High Court. My lord, I pointed out that, my lord, in a DV case, which my learned friend also agreed, a person cannot be arraigned as an accused person. My lord, the pleader can represent. And thereafter, my lord, to that certain extent, my lord, some amount of relief was granted to me. Well, this petition was also filed at the same time. But in this case, what has happened, my lord? After filing the DV Act also, my lord, now they have filed a petition under Section 200, basically a complaint case, alleging that, my lord, the petitioner number 1 and the petitioner number 2 have committed an offence under section 354 and 498A/506 of the IPC. They've just made a categorical reference that, my lord, on a particular day when the lady had come before the court premises for hearing, my lord, the applicant number 1 and the applicant number 2. The applicant number 2 is the uncle of applicant number 1, a senior citizen, my lord. Categorical reference has been made in the complaint that, my lord, we have committed an offence, we have, abused her, lord, etc., etc. Now, interestingly, my lord, after the complaint is filed, my lord, lordship, I'll take you directly to the impugn order, which is at page 101. This is the order summoning me as the accused person. This is order dated 5/10/2021.
Complaint before the court.
Before the court of the magistrate. So, my lord, the magistrate. Page 101. 101. Annexure 3. This is the type copy. Without any application of mine whatsoever, my lord, solely on the basis of the complaint and an examination of the complainant on affidavit, which is absolutely not permissible. I'll take that.
Where is the order?
Well, order, this is the order, my lord, type copy 101. 5/10/2001. If I may read out, CR put up today, counsel for the complainant is present and submits list of witnesses. I have perused the statement of the complainant and deem it fit to take cognizance in this case, issue summon to the accused person, complainant to take steps. Well, there is no application of mine at all. There are two aspects of law involved over here, my lord. Here, my lord, what has happened? The statement of the victim, statement of the complainant there is recorded by way of an affidavit, which is not permissible in a CR case, my lord. She has to stand in the dock on solemn affirmation. Her statement is recorded, on the basis of which the court is satisfied, then the court will issue process. Even, my lord, this can be done away with if the court is only satisfied on the basis of the complaint also, process can be issued. However, there is a rider, my lord, that is, if the accused persons are not the residents of the jurisdiction of that particular court, they reside outside the jurisdiction. 202, my lord.
That is a must.
That has not been complied with, that is mandatory.
Inquiry has not been conducted.
No.
So then, goes.
Absolutely mandatory.
No. Does not go it.
That is my limited case, my lord.
What, anything?
Lordship, let my friend finish.
No, but that is if that be the thing,
Lordship.
then why to proceed further? If he doesn't have any other point.
My other point is, my lord, there is no case made out.
He has other points.
So that is not the position of law. That 202, non-adherence to 202.
The order will be set aside, but the proceedings cannot be quashed.
So if
only the order will be set aside. The matter will be remitted back to the court.
If this order goes, then what will be the consequence?
Consequence will be the matter will be remitted back to the trial court for taking up the matter afresh. The court will have to comply with 202 and pass fresh orders. Yeah, just on that sole ground of non-compliance of 202, because that would be the fault of the court, the litigant cannot suffer. The matter cannot come to an end. That is my submission.
That is a decision of the apex court.
Yes, there is. My friend is aware of it.
Both relying on the same judgment. Well, I agree. To that extent, I agree with my learned friend. But I have other points to make also before this honorable court. Now, my lord, I am here before this honorable court in a petition under 482. My lord, I am here for the ends of justice. And why do I say that? Is because my lord, lordship knows the entire proceedings over here.
If you say therefore,
They are absolutely abusing the process of court. Complaint after complaint is being filed. Not satisfied by filing a complaint against the husband. Now they have arraigned the uncle also. And the reason why the uncle has been arraigned is to put pressure. Ultimately, the aim is to get a hefty amount of alimony. Well, if that is not the abuse of the process of court, what is, my lord? Not just one petition, petitions after petitions are being filed. And if my learned friend can point out from his complaint, if any offence is made out, just by writing 2 paragraphs, the court cannot be convinced to issue process against me. Of course, my lord, I'm agreeable to what my learned friend has said. Just because a particular provision has not been complied with, which is mandatory, of course, the entire petition will not go, because that will otherwise be the fault of the court.
In all cases.
I'm sorry, my lord.
In all CR cases, like that.
Not on all CR cases, my lord. See, my lord, in cases where the person... My lord.
Of course, we do not know, that is your matter, you argue, which way you argue, you are the best.
Lordship.
But in any case, supposing before issuance of process, just court issues it mechanically.
Exactly, my lord.
And the High Court interferes. Will it be case that it will be remanded by it again?
No, well, in that case, the entire thing will be quashed. Now, my line of argument here is, my lord, why I am coming back to that is because, my lord, when I say there is no case made out and the court has issued this order summoning me, my lord, my valuable right is being infringed, my lord, my liberty is being infringed. Now, without any application of mine, you say that I have read the statement of the petitioner and I am satisfied. On what basis, my lord? There has to be a certain amount of inquiry. Even if I do not reside outside the jurisdiction of the court, the magistrate has to apply its mind to say that this particular offence is made out after reading the statement or the pleadings.
Yes, you're correct.
Nothing is there.
Definitely, because 202,
My lord.
why it is there? 202 does not make inquiry in respect of a local accused mandatory. But then for outside it is mandatory.
My lord, because
just to create a layer of protection.
Absolutely,
So that
my
the
lord.
outsider person is not harassed.
My lord.
That is the purpose.
My lord, that is
the mandate of, if it is not done, then think definitely.
My lord. The thing is that, my lord, if we go through the complaint once, my lord, if my learned friend will point out anywhere that he has actually made out a case for the court to issue process, then, my lord, I'll give a reply. My lord, my submission is to this extent that, number one, my lord, an affidavit, statement on affidavit in a CR case is not permissible. Section 1 of the Indian Evidence Act makes it very clear an affidavit is not evidence. Number two, my lord, the mandatory provisions under section 202 has not been complied with. One resides in Calcutta, the other resides in Guwahati. Number three, my lord, nowhere in the pleadings any case under 354 or 498 is made out. And my lord, there is a delay in filing this particular complaint also. Of course, my lord, my learned friend will say it's a continuing offence. But his case is that, my lord, one particular day when we come to the court for settlement, outside the court, my lord, this girl was molested and offence under 498 was committed. How is that permissible? 354, that is your case. It is very, very clear, my lord, they are abusing the process of law, my lord. They are pressurizing me to pay half the sum of money which I cannot pay.
Why don't you go for settlement in this kind of case?
No, we have. What my friend is
There
saying,
is no-
hefty sum, this is not.
There
this
is no
not
pleasure
correct.
handling this kind of cases.
Absolutely. No pleasure for us as well. But clients do come to court. They feel that they have been.
You see, it is not a that thing that we have to try to avoid. It is not that.
No, I
but then it is always like in a.
We've made attempts. We've genuinely made attempts, but what is coming from the offers coming from the petitioner is not acceptable. And my friend will say it's 1.5 crores and so on. It's not that. It's an amount because she's married. She has a child. He's a gambler. He's an addicted gambler. He claims
doesn't have
now.
money,
He claims
my learned friend is.
Let me just explain. He claims this. He claims this that he has no money. He claims he has no money at all. Nothing to pay. Till today, he has not paid his wife or his child any money whatsoever. No maintenance.
That is also.
My lord, the only thing
He's
that
trying to
this
paint me in
person
a bad picture. I understand that is the job of the husband,
That is
but
also very-
we have to deal with it a little differently.
My lord, I
A
totally,
little differently.
I want
It's
to
a family
pay-
dispute.
Well, the only thing I have been given from my ancestral property is a flat. That, my lord, I'm willing to share half of the proceeds by selling the flat. I've made it very clear. I have nothing else, my lord. My learned friend will not succeed in getting
You are a
anything out of me.
businessman.
The
You are a
only thing I
businessman.
have is that one.
You are a businessman.
My lord, like my learned friend said, I'm a gambler.
No.
Part of the addiction.
My lord, it is a fact, my lord. This person, well, obviously, my lord, of course, it doesn't feel good to say, my lord, but the person has this vice of gambling. And that is why, my lord, he's been thrown out of his
Anyway,
family
you see,
property.
like you may have many people have those kind of vices. The thing is that you should not neglect your responsibility.
My lord, the problem is that,
You
my lord,
may carry on, go ahead with your thing.
it is always the husband.
If you cannot
who's-
control yourself, but
It's
then
always the husband who's made to look like a villain, my lord.
do not make others to suffer because of your bad habit. That is what.
My lord, the problem, my lord, here, my lord, lordship is an application under 482. My lord. I am trying to project that, my lord, this particular case has been filed by abusing the process of law, only to pressurize me. Well, and I believe to a certain extent, my lord, I have been able to satisfy lordship that this is such a case. Now, my lord will see the complaint, my lord, of the learned. My learned friend has been made to able. Generally, my lord, when a complaint is filed before the court, a CR case is filed, my lord, then what happens, my lord, after perusal of the complaint, the court has come to a satisfaction that this particular offence is made out. Then only process can be issued. My lord, there are so many judgments which I'll place, my lord, which
Exactly. You
issuance
see, you
of-
do not have to say it. See 204. Section
My lord,
204 will
absolutely,
clear
my
in
lord.
existence.
Absolutely, my lord. So, my lord, what has happened over here is, my
Issue
lord,
of process.
categorically, my lord, I just present a petition say that this offence has been committed, my lord, without application of any mind, my lord, the magistrate issues process. I have to come all the way from Calcutta. My uncle, who's an old man suffering from so many ailments, has to come and appear in the court every day, on every date fixed, and the kind of anxiety I have put into, my lord, for the husband, I do understand, my lord, he may have done something wrong, but for the applicant number 2, my lord, nothing is there, my lord. At least in respect of the application for the applicant number 2, my lord, no offence, nothing at all is made out.
So you give me your things. Then let us go with the hearing. We'll just note down the points and all.
This is
If
my
you are not-
submission.
If you are not willing to compromise, then to what?
Well, we have been trying so hard to compromise. Well, of course, well, I've made every single endeavor. Now, well, if I cannot make to be paid something which I do not own. Now, my learned friend says I'm a gambler, my lord, maybe I'll have to, whatever I have also, that I'll have to go and gamble. And if I have a good day, perhaps, then, my lord, I can pay whatever he wants, but then, my lord, it's not permissible.
That you will not do. If you are a real gambler, then you will keep it to you.
Everything will go, my lord. But what has happened to this man is, my lord, the petitioner number 1, my lord, his entire family is disowned him. It is a fact. Well, I'm before this court, I'm pleading. It is a fact that, my lord, he has been disowned because he has this habit.
So you do not want to correct yourself.
My lord, I want to correct myself, but my lord, I want to.
Instead,
in fact, I want to be back with my wife also, my lord.
Instead, you will go ahead with this.
I even don't want divorce from my wife. Well, I want to rectify myself.
If you do not want to correct yourself, then it is good that you should be dragged in litigation.
No, well, I want to correct myself. In fact, I don't even want to give divorce.
You have to be regulated.
I am resisting the divorce also, my lord. I don't want to give divorce. I want to meet my child also. Well, I have not even met my child. Husband is always the villain.
You yourself, you are saying that you have some habits
But
because
that is
of
what my lord has been reminded, my lord. But it is
because of which your own family has discarded you. But even in spite of your now,
well,
you say
I am seeing that because, my lord, when we are talking about settlement, my lord, the problem is that, my lord, the kind of amount which is being asked, my lord, it's not possible for me to give. I am willing to sell the only flat which I have, and I am willing to share half the proceeds. I made it very clear to my learned friend, my lord. I have nothing else. Well, apart from that, my lord,
increase it from half to 60%, 70%. Mr. Shell,
trying, my lord, they're adamant. They're adamant. Of course, he has come down from 1.5 crore, which is quite a considerable amount, to 40 lakhs. But otherwise, my lord, even that is not possible for me. But, my lord, that is a different thing altogether. My lord, I am here on this petition under 482. And I have argued my points. One is on 202, which is mandatory. And the other is that, my lord, this order taking cognizance, so non-speaking order, there is no application of mine. And the complaint does not disclose any offence at all. That is my case, my lord. And when, my lord, 202 is not complied with, then, my lord,
you just go a bit slow.
Sorry.
Yes, what are the points you said shortly?
First of all, my lord, I say that the order of taking cognizance has been mechanically taken without any application of mine. Number two, my lord, applicant number 1 is a resident of Kolkata. Applicant number 2 is a resident of Guwahati. So the mandatory provision of 202 should have been complied with. Inquiry should have been held. Number 3 is the court has. Sorry. My lord, number 3 is that.
Wait. One.
I am so sorry.
202 non-compliance.
No. Which is a mandatory.
And number 3?
Number 3 is that, my lord, the statement of the complainant recorded on affidavit, written affidavit, that is not permissible, my lord, in a CR case.
So the issue of process was based on
the basis of the statement.
Yes.
Lordship will see the impugn order says satisfied with the statement. So the statement on the basis of which the court came to a prima facie satisfaction that the case is made out was filed on an affidavit, which is not evidence as per section 1 of the Indian Evidence Act.
So means issue of process on the basis of affidavit is illegal.
It's illegal, my lord, in a CR case. In a petition under
yes,
it's absolutely
illegal. Definitely there is this thing.
And also under the Negotiable Instrument Act, that is permissible, but a petition under for taking cognizance of a complaint under section 2 is not permissible. And last is, my lord,
where is that affidavit?
The affidavit is not here, my lord. Affidavit is not here, but my lord will see the. It's very clear that on the basis of the statement, impugn order talks about on the basis of the statement, the process has been issued.
Where?
101, my lord. I peruse the statement of
the statement whether it is recorded during. So
well, there were 2 cases, my lord, in the DV Act. It was recorded like
that. Is it correct that it is issued process?
I don't have any reason to disbelieve my learned friend. It's a very old case. I came prepared on a different point. Today he's raising this issue as affidavit. I'll take instructions. But I don't think there's any reason to disbelieve him. Most probably it was on affidavit.
If that be the thing, then how will you overcome that?
I'll overcome it. I'm not saying that that procedure is correct. That procedure is incorrect. Also, non-compliance of 202 on the face of it is incorrect. I concede to that.
What about the affidavit?
That's incorrect. I would humbly submit that is incorrect, my lords.
The affidavit is incorrect. So statement was recorded in the court.
Statement is recorded on the basis of our affidavit.
He's agreeing to what I'm saying.
If at all that is the case, the 2 points that instead of making a statement before the court verbally, which is to be recorded by the court, an affidavit was submitted.
No, but then is it permissible in criminal law?
In NI Act is permissible, in other cases it's not permissible.
So this is not NI Act case.
This is not an NI Act.
Then this part of the part, how will overcome that?
So I'm saying, my lords,
What is the
which is
consequence?
why-
What will be the consequence of that?
So that
supposing
order will be set aside. The order whereby the court takes cognizance.
that is so for non-compliance of 202 or
For both.
For all.
For both.
Can
3
you pass
points.
us the order? Let us see. Please see. To what?
The order is at page
If
1001.
that is the thing, then anyway, please can you
My lord.
can I have look at that decision which you are referring?
Lordship.
You're referring to
Am I not audible?
No, I am. I apologize.
National Bank of Women.
Yes. So, my lords, here what had happened, a similar issue had arisen before the court. The accused filed a 482 application raising 2 grounds. Number 1, that there was a non-compliance of section 202 because the accused was a resident of an area which was outside the territorial jurisdiction of the court of the magistrate. And number 2, that on the face of it, none of the offences were attracted against the accused. Those are the 2 grounds. I'll just take your lordships to that. Kindly have page 3 of the judgment.
Yes.
Para 4 onwards. The relevant facts are recorded here.
Yes.
The respondent, being a citizen of India, necessary sanction had to be obtained from the central government under the proviso to section 188 of the code of the CRPC. Sanction was accordingly sought for from the Government of India and Government of India Ministry of Home Affairs by letter dated so and so, accorded sanction to inquire and conduct trial of the respondent by a court of competent jurisdiction in India. The CJM Ahmednagar on 25 to 2011 passed the following order on the complaint. Peruse the complaint and the documents attached thereto. The central government has accorded sanction to prosecute the accused, heard the learned counsel appearing for the complainant. There are sufficient materials against the accused. The complainant has made out prima facie case against the accused. Hence, process be issued for offences under 418 and 420 IPC. The respondent challenged that order by filing criminal application number so and so before the High Court of Judicature of Bombay bench at Aurangabad. It was contended that the allegations in the complaint do not prima facie constitute an offence or make out a case for issuance of process under 418 and 420 IPC. Further, it was stated that the respondent accused was a resident of Dakshin Kannada in the state of Karnataka, and the CJM Ahmednagar issued the process without complying with the mandatory requirement of making an inquiry or directing an investigation for the purpose of deciding whether or not there was sufficient ground for initiating proceedings against the accused as contemplated under section 202 of the CRPC. The High Court took the view that prima facie the bare allegation of cheating did not make out a case against the accused for issuance of process under section 418 or 420 IPC. Further, it was held that the CGM did not follow the procedure laid down under 202 CRPC. The High Court held that the magistrate was obliged to postpone the process against the accused and either inquire into the case himself or direct an investigation to be made by a police officer or by such officer as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding in a case where the accused is residing beyond the area in which the magistrate exercises his jurisdiction. The High Court noticed that the accused is a resident of District Dakshin Kannada, Karnataka, and hence the CGM should have followed the procedure later under 202 CRPC. The High Court therefore set aside the order dated so and so, issuing the process under 418-420 by the CGM Ahmednagar. Aggrieved by the said order, the bank has come up with this special leave petition. We find no error in the view taken by the High Court that the CGM Ahmednagar had not carried out inquiry or ordered investigation as contemplated under 202 CRPC before issuing the process, considering the fact that the respondent is a resident of District Dakshin Kannada, which does not fall within the jurisdiction of the CGM Ahmednagar. It was therefore incumbent upon him to carry out an inquiry or order investigation as contemplated under 202 CRPC before issuing the process. The duty of the magistrate receiving a complaint is to set out section 202, and there is an obligation on the part of the magistrate to find out if there is any matter which calls for investigation by a criminal court. The scope of inquiry under this section is restricted only to find out the truth or otherwise of the allegations made in the complaint in order to determine whether process has to be issued or not. Investigation under Section 202 CRPC is different from the investigation contemplated in Section 156, as it is only for holding the magistrate to decide whether or not there is sufficient ground for him to proceed further. The scope of inquiry under Section 202 CRPC is therefore limited to the ascertainment of truth or falsehood of the allegations made in the complaint, 1. On the materials placed by the complainant before the court, 2. For the limited purpose of finding out whether a prima facie case for issue of process has been made out, and 3. For deciding the question purely from the point of view of the complainant without at all adverting to any defense that the accused may have. Then, my lords, they refer to the purpose for which 202 was brought in. I'll just skip that, I'll come to para 11. We are of the view that the High Court has correctly held that the above mentioned amendment was not noticed by the CJM Ahmednagar. The CJM has failed to carry out any inquiry or order investigation as contemplated under the amended Section 202 CRPC. Since it is an admitted fact that the accused is residing outside the jurisdiction of the CJM Ahmednagar, we find no error in the view taken by the High Court. Now, this is relevant, Manoj. All the same, the High Court, instead of quashing the complaint, should have directed the magistrate to pass fresh orders following the provisions of Section 202 CRPC. Hence, we remit the matter to the magistrate for passing fresh orders uninfluenced by the prima facie conclusions reached by the High Court that the bare allegations of cheating do not make out a case against the accused for issuance of process under Section 417, 416, 418 and 420 IPC. The CJM will pass fresh orders after complying with the procedure laid down under 202 within 2 months from the date of receipt of this order. So there are two things. They agree that 202 has not been complied with, and on that ground, they set aside the order issuing process, but they also direct that the trial court should be uninfluenced by the High Court's conclusions that those offences are not attracted, because this affects the jurisdiction of the court. So on that ground, they would have interfered. They did not immediately quash the entire proceedings. So what my friend wants is that first, Lordship should set aside the order issuing process under 202 and also take up the issue of whether the offence is attracted at all. But going by this decision,
we are not on that.
Well,
the thing is, that's affidavit.
Lordship.
The issue of process basing on affidavit.
Lordship.
How far it is valid in law? In criminal.
I'll just examine that one. To be very honest,
that is the crux of the issue, it seems like.
Yes.
You see, otherwise one party here, this order impute, that particular order,
yes,
that cannot stand. As you see, that has to be remanded as per this decision,
yes,
what you say.
Yes.
But then in addition to do, he has that, addition to that, he has another ground, that affidavit.
Affidavit.
So that is what you, if you verify in that
Lordship. I'll just check that. I have no reason to disbelieve my friend, although that is not on record, and also the order does not indicate whether it was on affidavit or otherwise. I'll just check. I can come back with this information on Monday.
So supposing if it is found out it is on the basis of affidavit,
Lordship,
then whether that issuance of process basing on affidavit in correct in criminal law or not, that has to be decided.
Yes, Lordship. I'll just
otherwise he is correct. See, criminal law nowhere contemplates recording of evidence by way of affidavit.
Correct.
Unlike in a civil case.
Yes.
That is what.
From what I recall, it is not permissible. So on that ground, if Lordship set it aside and direct that the court should not rely upon the affidavit, I'm okay with that. But my concern is the quashing. Lordship will see in this case as well, the courts have said quashing is not.
If he can make out a case, then we will quash that.
No, that's what I'm saying. That is what I'm saying.
If you come with a definite set of.
No, that's what I'm saying. This judgment, the High Court had come to that conclusion. They'd come to two conclusions. One, that 202 has not been complied with, and number two, that the offences of 418 and 420 are not attracted. And on that ground, they quashed the proceedings. The Honourable Supreme Court said that initially there is a question of jurisdiction. There is a jurisdictional error on the part of the magistrate. So we don't need to go into that question of whether the offences are attracted or not. And the trial court will reappreciate the matter. Now, his grievances with regard to the trials and tribulations faced by an accused where he has to appear. The summons go. He does not need to appear anymore.
See, here he is challenging on two grounds. One is non-compliance of 202. Which is covered by this judgment.
Lordship.
Another part is the issuance of process basing on the affidavit.
So I'm conceding to that, readily conceding to that. I readily concede to that.
What will be the consequence of that?
So that will be set aside. It will go back.
No, so far as if interference only with regard to the non-compliance of 202.
202.
There are two aspects. Say supposing, 204 CRPC is there. Now 204 says court before issuing process must process. That means in process including in the cases where 202 has to be complied with. Okay. there their court has to come to a finding that there is a prima facie matter.
Yes.
It's not required detailed order should be recorded, but then
Lordship.
court should record its satisfaction.
Some amount of satisfaction.
Now, whether it means before issuance of process in this particular case, not only section 202 has to be complied with, 204 also has to be complied with.
Lordship.
Now, whether that dual of satisfaction as contemplated in 204 can be on the basis of the affidavit, that is what the main thing.
I understand. This can come back on Monday just to check on the question of the affidavit. Otherwise, in other way, I am conceding to that.
No, but then what would be if you
may
concede?
discard the affidavit.
If you concede, then whether that can be a ground for quashing or not, the entire process.
Respectfully submit no, my lords, because I'm saying that number 202 I'm conceding.
You are not here to say yes because you are even.
No, I'm saying, my lords, that 202 on the ground, on the face of it, it's wrong.
Any law in this regard?
My lord, there is a judgment of the Calcutta High Court. I don't have it with me right now, my lord.
Please then find it out.
And
This,
also, my
this is quite. It seems like quite interesting.
My lord, it's very
It will
interesting.
be learning for the court also.
My lord,
If you
technical. We have argued on the technical aspect. I agree to that National Open Bank. That is the law, my lord, as of today. We know. But my lord, apart from that, my lord, I have not on merits. I have not touched the case yet. So my lord, we can have it on Monday if you want together. Because on merits also, I'll place some judgments, my lord. They cannot make such categorical allegations, and the court will stand up and issue process.
No, that's what I'm saying.
Right center.
In this particular case, as lordships have noticed, the High Court had touched on both the issues, the jurisdictional issue under 202 as well as the merit of the case. The Honorable Supreme Court said merit is not required to be gone into when 202 itself is a jurisdictional error. So once there is a jurisdictional error, we should remit it back to the trial court to correct itself.
See, issue of process.
Lordship.
Basically, 202 comes when an accused resides outside jurisdiction.
Yes.
Okay, but then first is issue of process, and then you would see who is local, who is not local.
Yes.
Okay, so 202 is to be complete. 202 definitely court can direct even for a local accused also. It is up to, but then it's not mandatory.
It's not mandatory.
But then what means is that the first this thing so supposing if court finds that there is no merit in the thing, then coming of 202 into operation does not arise.
Yes.
If you're so that is why what he has pointed out to Mr. Gautam here is that the affidavit, the very basis on which the court forms
in opinion,
its opinion.
Yes.
Now whether that can be derived on the basis of if without the person being concerned being examined.
Lordship. So my understanding is, number one, there are two situations contemplated under this process. One is that the accused is resident within the jurisdiction of the court. There is no need to resort to 202.
Maybe
the court
it is
will
not
simply
mandatory.
examine the complainant and witnesses, if at all, and then issue process. In the case of 202, the court will assume jurisdiction only after completion of the inquiry, only after resorting to 202. So there it becomes a jurisdictional issue. So court cannot even assume that any of these statements are true without conducting inquiry. Now, inquiry, there are two forms of inquiry. One, that the court will direct the jurisdictional police station to commit the inquiry. Alternatively, the court can conduct the inquiry by itself. In fact, there are decisions of the Supreme Court where it says, in such cases, the court will examine the witness, examine the complainant and witnesses, and then come to a subjective satisfaction. That would be sufficient amount for an inquiry. That would be sufficient excess for an inquiry, as contemplated under 202. Once the court completes that, the court can issue process. That would amount to sufficient compliance of 202. So my case is, let's assume for a moment that 202 has not been complied, which on the face of it is correct, and I'm conceding to that. Lordship's query is with regard to the affidavit. Even if I concede that the affidavit is incorrect.
Just if you can stop for a moment. Now, as you say,
Lordship.
The 202 is the second stage. First stage is that you see whether there is a prima facie case or not. If a complaint comes before a court of law,
Lordship.
court without resorting to anything is not going to 202. Is it?
My understanding, my lords, is that the moment the court notices the array of parties, that one of the parties is a resident of an area which is outside the territorial jurisdiction of the court, it has to immediately resort to 202.
Just see, 202 again contemplates that even for a local person, this inquiry can be conducted. Now, if you see array of parties, we can make out who is residing within local jurisdiction, who is residing outside local jurisdiction.
Yes.
Okay. Now, in such a case, to make application of 202 in case of a local person, the court has to go through the allegations.
Yes, correct.
Isn't it? So 202 stage comes later. It will come only when court takes into cognizance or decides on the merit of the application.
There, Manoj, I would respectfully disagree. I'll satisfy Lordships on that point. My
Because
understanding.
If you come to 202, it contemplates inquiry. Okay, it says that inquiry in respect of persons residing outside the jurisdiction is mandatory.
Yes, Lord.
But then for local person, it is optional. The court may.
Lordship.
Court may or may not.
Yes.
So the court may means like deserving cases, court may order also.
Yes.
Then if in case of a local, just for the sake of argument or for better understanding of your argument, for a local person, if 202 is to be applied, will it be the same criteria? Just see the area of parties and you do it.
No, no. In that case, what I'm trying to convince Lordships or trying to place before the court is for the court to resort to 202. Court will naturally have to look at whether accused is a resident of. If the court finds that the accused resides within its own jurisdiction, court will not resort to 202.
No,
the mandatory provision of
then
202.
just tell us one thing. If any complaint is filed in respect of an accused who resides outside the jurisdiction, so it means 202 is the sole criteria of issue of notice.
Yes.
No,
on the basis of that, the court comes
just
to.
Just a minute.
Lordship.
Have patience, please. You will have your chance. We are having. See,
Yes,
it's a learning, please, kindly.
Grateful.
Now help us explore in that way. Court is not expressing any view, and this is now.
I just wanted
Now,
to answer that.
so supposing where this is, so it means once 202 is complied with,
Lordship.
a report comes, either court inquires itself or police report comes.
Lordship.
That can be basis of issue of process.
Yes.
So
Not just that.
This means this person concerned, the complainant is not required to be examined.
No, it's required to be examined. I'm not saying it's not required to be examined.
So, 202 before examination of the complainant or after examination of the complainant?
Together, my lords. What I'm trying to say is that when it comes to 202, 202 contemplates an inquiry.
Just let us confine the question to this. The court before ordering an inquiry under 202, whether needs to record the statement of the complainant or not?
It does.
So that is what.
Of course it does.
So that means the very first part. That is what this basically the court is trying to get clarified. You see, like we try to basically ascertain from you that if this examination of a complainant is to be done prior to the stage of 202,
Lordship.
in such a case, whether that examination can be done in the form of affidavit as raised by him.
If Lordship kindly, I understand Lordship's questions. Which comes first? Upon receipt of a complaint.
Which will strike at the root of the proceeding. That
exactly. As soon as a magistrate receives a complaint and realizes that the accused is a resident of a place outside his jurisdiction, what should it do? Should it resort to 202 or should it resort to 200 and first examine the complainant? So if Lordships will kindly have 200 and 202.
Yes, please.
To be honest, I have not examined this case from that point of view that Lordships are posing the question.
That becomes a vital point here.
Lordship. So I'll just
question if Lordship will allow me.
You
can answer. I can answer that question, my lord. The query which Lordship was.
See, your answer will be definitely. Will have. He also has the answer.
No, I am learning it myself.
He also has the answer. It is not that he doesn't have the answer. Let us first hear his answer.
Yes.
Then we will go on.
I answer in a very neutral way regarding this query.
All the counsels are expected to be very neutral.
Yes, my lord.
That is the duty of the counsel.
Absolutely.
To guide the court to the correct conclusion.
Yes.
That is what. Yes.
Lordship. So the language used in chapter 15, kindly see section 200. Examination of complainant. A magistrate taking cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses present if any, and the substance of such examination shall be reduced to writing. So this leaves no doubt in the mind of the court that there is no question of an affidavit. It is recorded verbally and then it is reduced into writing.
202 now.
Yes. I'll just finish this minute and shall be signed by the complainant, witness, and so on and so forth. Then kindly see 202. Any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance.
So that is what. Kindly just hold for this.
Lordship.
Now, how he decide he is authorized to take cognizance?
It's on the basis of the jurisdiction, on the basis of the offences. If those offences are triable by the magistrate.
That means before you come to 202,
Lordship.
court first has to take a decision whether it is empowered to take cognizance or not.
Right. After examining, after going through the entire complaint.
Yes.
Any magistrate on receipt of a complaint. Now kindly see the language of an offence which he is authorized to take cognizance of. So this has to be read together. So the satisfaction of the magistrate with regard to its own cognizance will be based on the nature of the offence, whether it's triable by that magistrate or not. So in case somebody files a case on of murder before the magistrate, he obviously does not have the authority to take cognizance. It is only in that context where this expression has been used, in my humble understanding. That's why it says any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance, or which has been made over to him under section 192. So there are two circumstances, one committed and the other where it comes directly to him and he examines whether he is otherwise entitled to try that, authorized to try it. May, if he thinks fit. So may, if he thinks fit, in all cases where the accused is a resident of an area within the territorial jurisdiction of the court. So that is the discretion of the magistrate. And shall, this becomes peremptory. And shall, in a case where the accused is residing at a place beyond the area in which he exercises jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding, provided that no such direction shall be issued in such cases. Now kindly see for a moment that decision again, Manoj. On what basis the court arrives at that satisfaction? Page 5. If Lordships have it, page 5.
Yes.
The first paragraph, the third line from the bottom, which starts from page 492. Page 492, internal page. That first paragraph, which I was reading earlier, the third line from the bottom, it reads the scope of inquiry under section 202.
Yes, yes.
The scope of inquiry under section 202 CRPC is therefore limited to the ascertainment of truth or falsehood of the allegations made in the complaint. Now, these are the three the materials on the basis of which the court can come to that conclusion. On the materials placed by the complainant before the court, which means the complaint along with whatever annexures. Then, for the limited purpose of finding out whether a prima facie case for issue of process has been made out, and for deciding the question purely from the point of view of the complaint without at all adverting to any defense that the accused may have. Now, I think Lordship's question was, at this stage, should the court first resort to 202 and direct an inquiry, or first record the statement of the complainant, if I understand Lordship's question correctly? So, my lords, in my humble submission from a reading of 200 and 202, once the magistrate has that, the magistrate may take the statement of the complainant and or, because here the issue is the inquiry which is contemplated under 202. It has been held that inquiry could mean the court directs the inquiry to the jurisdictional police station or takes up the inquiry itself. In such a situation where the court takes up the inquiry itself, the manner to conduct the inquiry is the statement of the complainant and the complainant's witnesses. That itself is sufficient. So I believe, in my understanding, for the purpose of that inquiry, the statement of the
second thing is adopted by the court, inquiry by itself. It will be a compliance of 200 also.
Yes, yes.
But then the first part is not in. This is something different. Say supposing if we ask for an inquiry with the police, then this will not be necessary compliance of 200.
It may not be, but in my humble submission,
in the event where court enquires inquiry by police, whether 200 is needed to be complied or not.
I understand it would have to be required. Has to be required.
So it means if it is required,
Lordship,
and if process is issued, moment you say 200, then 204
yes,
also
yes.
come into
Why I'm saying this because 200 is mandatory, the examination of the complainant. What 202 contemplates is postponement of issue of process. So
exactly,
only after the examination is complete.
It is 202 is nothing, one extra layer of protection.
Yes, yes.
That court must be very sure before issuing process.
So there is the complaint, then there is the statement of the complainant in the manner prescribed under 202, under 200, and then the question of an inquiry comes in. So the statement of the complainant is necessary, and only then can the court decide whether to postpone process or not. So if the person is residing outside, it has to be postponed only after committing the inquiry. This is from a reading of 200 and 202.
But then what about the affidavit aspects?
So I'm saying, my lords, if I'll just examine that, to be very honest, but I'm saying I'm readily conceding. But that does not mean that the entire complaint has to be quashed.
That is what you just show us what would be. See, 202 is very much specific. He said like only statement by the court. It is not that it has to be on the basis of that. But then what happens if non-adherence of that is there?
Well, my small reply, well, it's a neutral submission. But my learned friend has said that examination of complaint is absolutely necessary. That is not correct, my lord. In cases when I make a complaint before the magistrate, if the court is satisfied on the prima facie complaint, the case is made out, process can be issued. That will be legal. And also, my lord, similarly, if the court is satisfied that no case is made out, then the court will resort to 203 and dismiss the complaint without even examining it.
No, my lord, I was
That
answering
is
the
very
question in
clear.
a different context.
Your Honor will just read the proviso, provided that when the complaint, I'm reading 200, my lord, speak in writing, the magistrate need not examine the complainant and the witnesses if the court is satisfied. And similarly, my lord, if the court is not satisfied that any offence
You are
is made
referring
out,
to. You are referring to just a minute. Just.
section 200, my lord, the proviso.
Yes.
Just,
Yes. Provided when the magistrate. Acha, yes.
Not always necessary. It's not absolutely necessary. There are exceptions to the rule also. So, well, what I'm basically trying to say is, if a complaint is made before the magistrate, which does not disclose any offence at all, even if the person resides outside the territorial jurisdiction, there is no need to resort to 202. You can directly come to 203 and dismiss the complaint.
No, my lord, my
It's
friend
hard and fast rules.
misunderstands.
In every single complaint, you have to issue process. You have to apply your mind, and thereafter, whether you want to postpone the process or not, that is up to you. And you can also resort to 203.
Yes, you are correct. Yes.
That's my learned friend misunderstands. I was answering the question that Lordship had raised. That for the purpose, if the court is deciding to issue process in this context, whether it would be required to record the statement of the complainant and what is the manner. So here it says affidavit is not one of the processes. It has to be by recording it orally and then reducing the substance of it before the court in the records of the court. That is what I was seeking to answer. So now the question is, at what stage would the complainants, if at all the court decides that I want to record the statement of the accused, at what stage would it be recorded? Would it wait till the inquiry has contemplated a 202 or record the statement before? I am saying it would be done before. And then the court would take...
Yes, the query was confined to that.
That is the query I was answering.
Yes.
Naturally, if the court finds there is no sufficiency in the allegations, it would naturally dismiss it.
And we just clarify as on the part and all. Quite interesting. Seems to be quite interesting.
So the query that we need to answer is only on the question of the affidavit, my lord.
And also, I'll reserve my right to argue on merits also.
No, definitely. That will be open. But then since so today it's a kind of a gathering idea about the matter.
Yes,
so we'll have the detail.
It's a very interesting case. There are many cases like this only. They start from marriage.
At so and so. Then you say on the joint request list after a week. We'll have it after a week.
After 2 weeks.
Lord, after 2 weeks.
After 2 weeks. List after 2 weeks.
Highly obliged.
Much obliged.
Item number 11.